Now for what's trending in true crime, a status hearing next week could determine what evidence can be used against a young woman accused of killing her newborn baby. Alexee Trevizo was only 19 years old when she had a baby in a hospital in New Mexico. Now the baby boy
I remember this one.
was found dead in a bathroom trash can. And we want to show you the video that her defense attorney doesn't want the jury to see. In it, Trevizo is seen and heard talking to police on body camera footage, and this is after the baby was found in the trash can in the bathroom. Now, her attorney says that this video violates HIPAA laws.
She put the baby in the trash can, and then she put another clean liner over the top of it.
Oh, wow. Okay.
So when they looked in there, there was no trash in there, but it was underneath the clean bag. The baby's dead. Okay, we have him in trauma too, but she killed the kid.
Yeah. How old was the baby?
I don't know. It's full term.
So the judge sided with the defense team on this to not show it to the jury, but the prosecution is appealing. So we're wondering, how should the appellate court rule on this? Should they reverse the decision? Let's bring in our power panel now.
Oh my God, they're trying to say it's HIPAA because it was at the hospital. Like the doctor or whoever that was, the nurse or the doctor, shouldn't have told the police what happened. But, oh, man. Oh, how are they going to rule on that one?
So with me, former special agent with the Georgia Bureau of Investigation, Trebor Randall, criminal defense attorney and former prosecutor Michael J. Brown, and trial attorney and law professor Dante Mills. Great to see you all. Dante, would you start off our conversation for us, please? Your thoughts on who's right here?
I think the court got it right. Good morning, everybody. In these types of cases, there's just constitutional protections that everyone has. And during the course of investigation, no matter what that investigation is, you have to do things the right way. So what the prosecution is arguing here is kind of they're trying to have their cake and eat it too. So there's two protections that should have been here. One is a HIPAA protection that violates your health privacy. And the other is the protection against being interrogated against your will without being given your rights. The prosecution is saying that they kind of canceled each other out, that the doctor was in the room, so the interrogation wasn't just the police, and the police was in the room, so her comments to the doctor are not protected by HIPAA and the health privacy violations. So I don't think you should be allowed to do that. The judge said that those things crossed over, but they don't cancel each other out. I think that's the right decision. And I think the appellate court should uphold that ruling and say, if you're going to interrogate, you have to make sure you follow those rules. Isolate the person, give them their rights. And if they decide to speak with other people around, that's one thing, but you can't cloud the situation and try and use that for your benefit.
Appreciate it, Dante. And let's take it a step further. I really appreciate what you said about.
What do y'all think about that?
If the police didn't get it right, Trebor, this is where I want to go to you, please. What could they have done better in your view here?
Well, I would have to agree with them. The rules still apply. If you're going to do questioning of an individual regarding a crime, you definitely need to take that into consideration. What does the environment look like? Is that individual free to leave? Who's present during the questioning? Typically, our test as law enforcement is going to be, was it custodial? Custodial questioning, that's usually the 2-tier, but there's still an issue that we take up. Is the person going to be free to leave after they tell me what it is they're about to tell me? So you have to be thinking about all of that at the onset of that initial contact, that initial question and answer segment.
Appreciate it, Trebor. And last but certainly not least, Michael J. Brown, let me go to you here in what, if anything, these prosecutors can potentially do here, because part of what they want to establish is they want to try to show the jury that she knew that she was pregnant, that she knew prior to this and wasn't telling her family or anyone, and knew what occurred when she was in the hospital bathroom.
I remember people saying the mom knew. You remember that? They were showing pictures of her like at the prom or whatever it was, or in her cheerleading stuff, and you were like, excuse me? YouTube, by the way, hit the subscribe button if you like true crime. My name's Patrick. I'm live every single night. Make sure you leave a like on the video. Let's keep going.
How do you think they may go about that if the court does what Dante expects the court to do, upholding that trial court ruling?
It's going to be difficult, Julie. I think what they're going to have to be able to establish is on prior occasions, maybe she bought certain things from a pharmacy or she went to doctor visits and there was some indication that she was pregnant. But going back to the issue, I think the professor hit it on the head. You know, public policy mandates and requires and expects that you're honest and forthright with your treating doctor, regardless of who is in the room. That's why it's protected. And the analogy I would give is when you go up to the triage nurse, even though there may be a gentleman standing next to you who's unrelated to the case, you're still protected because the law wants you to be able to be honest and forthright so that the doctor or the treating medical personnel can treat you appropriately. So I think the government's argument is going to fail, and I do think this is a HIPAA-protected situation.
Michael, appreciate that. Now let's take things a step further and look at the civil case together. So she's got the criminal case, but then also Alexee Trevizo is suing the hospital. And what she's maintaining is that the drugs that she was given are what killed the baby. She's saying that she didn't know she was pregnant. We found a TikTok video of her cheerleading. And take a look in the video. She appears to be pregnant in the video. This video has drawn a lot of speculation, a lot of comments, a lot of people watching her case closely are saying, how could she not know? But her lawyer is saying she didn't know, and it's the hospital staff's fault for killing the baby by giving her medications like morphine. And the lawyer is saying that there's civil liability the hospital has here because they didn't pregnancy test her before administering the medications. There she is in the middle of the screen there. All right, so what liability, if any, civilly does the hospital have? Back to our power panel. Michael J. Brown, would you start us off this time with your thoughts on the civil case, please?
Julie, I think what also has come out, in addition to what you just said, is that the hospital determined fairly quickly that she was pregnant and continued to administer the morphine and the additional drugs. So,
oh my God.
While when she comes in and they're doing the morphine and they're treating her alleged back condition may be perfectly fine for medical standards, the minute they become aware that she is in fact pregnant, from their testing, and they continue to administer these pretty significant drugs that, hey, look, if you have an expert that comes in and says that contributed to the death of the baby, then yeah, I think these trained experts are certainly on the hook for not cutting it off once they became aware that she was in fact pregnant.
Great point, Michael. Trebor, to you next, please. Your thoughts on that video evidence and whether you think the hospital bears any responsibility here.
I think, as we know, the civil situation is always different from a criminal trial. I think that the hospital certainly is going to bear some responsibility based on the timing that they knew they had gotten the results that she was pregnant and what their actions were after that. They didn't approach her with it. I believe the nurse wanted to wait on the doctor, for example. They continued to administer the morphine, allowed her to go to the restroom after she mentioned needing to use the bathroom, which most, moms know that that's oftentimes a signal that the baby is about to, come out. So I think that there's going to be a lot of question there as to what they knew, when they knew it, and what they could have done, but mostly a question for the medical examiner as it relates to the amount of morphine that would be in the baby's blood, and would that be a lethal amount, and whether or not it was a fetal demise versus, a healthy delivery, which we may or may not ever know.
Good points, Trebor. When you said medical examiner, my ears perked right up. I'm thinking, can't the forensic pathologist, who examined the baby give us some answers here? Dante Mills, take us home if you would, please. Your thoughts on the civil case and whether the hospital is in trouble.
I think it's very interesting that what will be used in a civil case kind of strengthens the criminal case. So if the hospital was trying to show, or the prosecutors are trying to show that she should have known she was pregnant, that there were clear signs that her baby bump was there, all of those things would then translate to the medical professionals who should have recognized that as well. And even if she came in and told them she was only experiencing back pain, if they're going to give her morphine, there has to be some other questions and evaluations that are done. And if it was so obvious that she was pregnant, they should have recognized it. Now, there's some other evidence, though, that suggests that she knew she was pregnant. Some of her friends said that she talked about it, that she, in fact, even named the baby, said she was going to name him Alex. So there's questions here about how long the mother knew, but the facility should have known and picked it up during the process, at least, of treating her with morphine. It is clear, the medical examiner said that the baby was born with air in the lungs, which indicate that it wasn't a stillbirth, but was it morphine that does have the impact of causing difficulty in breathing for a newborn, and that's ultimately why the baby died, or was it strangulation, which is what the prosecutors are saying happened here in this case.
All great points to think about. We've got to leave it there. Dante Mills, Trebor Randall, Michael J. Brown, thank you for the great discussion on this one. We're watching her case closely. We'll see if the appellate court touches that ruling.